that, Danny. Hello, everyone.
Hi, Henry.
Hello.
Hi, Shirley.
So I see people are dropping in just now. Would give probably
5 minutes.
seconds. Yeah, Mohammed?
Yeah, we can have 5 more minutes. Yeah.
Okay. Okay. Hopefully less. Okay.
You're looking good.
Absolutely. In the meantime, Shirley, I'm going to give you, okay, yeah, you already have the rights to share your screen. You have the access now. So, yeah, you have everything you need. Waiting for every other person to come into the room. So if you're just joining us and you're wondering what's happening, that's what's happening. We've given ourselves a 5-minute buffer to get everyone in the room. And we will be starting in full speed in the next 1 minute, actually, to get set. Okay, Shirley, please take it away.
Thank you for giving me this opportunity to present to you the fundamentals of IP. My name is Shirley and I'm from Singapore. So I graduated with a PhD in biological sciences from the Nanyang Technological University, and I have 10 years of experience working in 3 major university technology transfer office, NUS, NTU, and SUTD. And I am a certified patent valuation analyst, and I was recently selected from one of the 38 participants selected from over 300 applications for the WIPO patent drafting course. So WIPO is the World Intellectual Property Organization. And during my free time, I help start up with the IP strategies and valuation. So the topic for today is unlocking innovation and a founder's guide to intellectual property. I believe everyone here is a founder, and this topic will be appropriate to you. So this is my LinkedIn. Feel free to connect with me on LinkedIn. And these are some of the startups that I work with in the university. So they are mainly medtech and robotics startups. So what is intellectual property? So is everyone, just to set the stage, does everyone know what intellectual property is? Has anyone filed a patent before? Okay, never mind. That seems like nobody has filed, not familiar with intellectual property. Then that's great.
I did try it previously.
So we'll say there are 5 main types of intellectual property, and they are divided into registrable and non-registrable. So what do I mean by registrables? Meaning that they have to be filed with a patent office. So registrable intellectual properties are the trademark, patents, and design. So for trademarks is to protect the distinctive sign. Like for example, the Starbucks. Like for example, the Starbucks logo. So that's a trademark. And patents is like to protect it. Is to protect the inventions. So for invention wise, there are 3 criteria which you need to fulfill when you file an invention. First of all, you have to meet the patentability criteria, which is to ensure that the inventions are novel. So it's different from the prior art. It's inventive, so it must not be known to someone skilled in the art. And lastly, it must have industrial application. So industrial application is the easiest to fulfill. Basically, you must be able to use it in some industry application. And then the third type is the registered design. Is more like protecting how an object looks like. Like for example, I want to protect the design of my cup. So I will have a design for like exactly whoever infringe on the design of my cup. If it looks exactly like my cup, they will have infringed on my design. If that's say, for example, they want to change the handle to something else, like maybe a sharper handle, then it will not infringe on my design. So that's the protecting the novel appearance of an item. So for the patents, it's very straightforward. So the patent lifetime is 20 years. So it's from the time when it's first filed. Then for trademark, it really depends on the country. Like for instance, Singapore, our trademark is renewed every 5 years to every 10 years. Then for India, it's also renewed every 10 years. However, for design, for us, it's renewed every 5 years until 15 years. So the maximum lifetime of the design is 15 years. So, but then in India, the first application once granted, you can have the lifetime of 10. Then you can renew it until another 5 years. So in general, the design is 15 years. Then for non-registrable intellectual property, so there'll be the copyright and the confidential information. So non-registrable means that you don't have to file with any patent office. So copyright is to protect your original expression. Like for example, you have a songwriter, or you are a producer of a producer of lecture. So this already have your copyright. So in Singapore, for copyright, it is for the lifetime of the author plus 70 years after the person's death. Then for India, it will be slightly different. It will be the lifetime of the author plus 60 years after the person died. So that is copyright. Then for confidential information, that will be for you to protect the private information. So something that is not general knowledge, and trade secret and is a subset of confidential information, which means that trade secret is like, let's say, has business value. And for, let's say, for software, you can sell something as a software. Actually, software, there'll be actually two types of intellectual property. There's copyright and confidential information, because the software itself, confidential information, the source code, the algorithm, all these are confidential information. Then I believe everyone is familiar with this fast food restaurant, McDonald's. Can anyone tell me like what are the intellectual property you can find in this McDonald's restaurant? Any idea?
Sorry, didn't hear you.
So, okay, for this, I'm just showing an example of a McDonald's fast food restaurant. Are you able to tell me what intellectual property you can find in this restaurant? What identity?
Logo.
Can you hear me?
The logo.
There's the logo, that would be like the trademark. What else?
That character mascot.
The character, the mascot, and also like the anything that related to McDonald's, like McCafe, McMuffin, all these are actually their trademarks.
Okay.
And if you are not aware, like also McDonald's in the past, they also have some designs and also patterns. How they prepare the food, the equipment they use, and how they package the food. So they also have these past intellectual properties, which also like patterns and design, which most likely they have expired by now. But this is some intellectual properties that McDonald's has. So moving on, we also have an example like this bottle of wine. Can you guess like what intellectual property this bottle of wine has?
If you
Is
want
it the shape?
notes in the chat as well, feel free. Feel free to unmute, to raise your hand, or drop notes in the chat.
So what kind of like intellectual property? Just now we learned like 5 types of intellect. So what kind of intellectual properties can you fit into this bottle of wine? What kind of intellectual property can it possibly have? Any idea?
Is it the shape of the bottle?
Is that the design, the shape of the bottle? That's one. What else? And sometimes also people may protect the design of the cork. So that is the design that possibly the wine producer may have protected for the wine. What else can you think of? Okay, maybe I give you some hint. So can you think of any wine that you can associate with? That is a name of the wine region, but then that's also what you associate with the quality of the wine. Okay, maybe I'll just share. I think maybe when we have some difficulty, maybe I'll just share. So like the trademark, so some there's some associated, right? That will be people will there's a intellectual property. So the type of intellectual property. Then the geographical indication is also a type of intellectual property. Like for example, I mean, so familiar with Champagne, but actually Champagne is the name of the wine region. But then we just know that we call the wine Champagne but actually it's the name of the wine region. And this is a geographical indication is also a type of intellectual property. And then the copyright that the design of the logo, that's a type of intellectual property. And also the design, right, that what your colleagues have said, the design, the border shape. So that is also another type of intellectual property. So just by a simple bottle of wine, there can be 5 types of intellectual properties. So like, for example, like a startup, how do you determine which type of intellectual property protection is right for a startup? So maybe anyone would like to share like what kind of startup you are doing? Is it more like a deep tech startup or a non-deep tech startup?
Then we have 2 volunteers who want to talk about their startups. But broadly speaking, I think a lot of the startups on the call are software related. But I don't want to make that assumption on their behalf. So 2 volunteers, just quickly tell Shirley the type of startup you run.
Hi, this is Mahira Habib. So I have just started my business. It's about mental health tech platform. So our product is actually developing. So we are going to launch very soon. So it's on mental health tech.
Okay, so most likely, if not wrong, it's more like an app, is it? Is it an app or a device?
Oh yes, we are actually trying to build an app.
So for
App and
wise,
website both.
okay, so for app website, so for app wise, it's more like, so it's likely to have it's a software and or there'll be a copyright and there'll be some algorithm source code involved. So that will be confidential information. And then for the company itself, you may have some trademark because you want to protect the brand of your company. And also maybe you will have some designs, some logo designs that or certain thing that you want to identify with your startup. They can possibly also have a design that you can protect. So these are the main types of protection that you can have for your startup. So usually we don't, for like software, we don't usually file patents because software usually there's always an enhancement. So when there's enhancement, then patents is a long process. And when you file a patent, after 1.5 years, you'll be on the public domain. So typically, if let's say you have a software startup, we will not encourage you filing a patent. So usually the type of IP that you want to protect is most likely to be software and confidential information for the technology itself. So just like I'll just share with you, like maybe you may have, besides the software startup, you may have other types of startup, like for example, like share with you some 3 case examples. I think the first one would be very similar to what Mahira has. It's more like a software application. So that will be more like we'll be protecting the confidential information and the copyright for the software application. So if let's say your startup is more doing like selling fashion apparels, so that will be more focused on designs and copyright because you will have a unique patterns and design. So that will be the type of IP that typically this type of startup will have. Then for a biotech startup, you may have a medical device. So because a lot of investment is put into the R&D for making this medical device, and especially if this medical device is revolutionary, it's most likely what you'll be protecting is most likely a patent because to protect the device. And if this device comes with a software, then there will be copyright and confidential information. So you can see that in a startup and the technology they offer, there will not be just one type of IP that we're protecting. There will be a combination of IP we'll be protecting. And the way to think of it, because for a startup, you always like budget constraint. So when you think of like IP protection, you have to first of all think of your budget, how much money you have, how much funds you have raised to determine whether you want to file a patent now or file a patent later, and whether a patent is suitable for your innovation. If let's say your innovation is more like a software, which is a type of technology that moves very fast, then typically we will not encourage you to file a patent because patent takes a long time to be granted. And then by the time the patent is granted, you may have a new version of the software, which means your patent not so relevant to protect your software. So typically, if let's say you have a software innovation, we typically would recommend not to file a patent, but more to protect it as a copyright and confidential information. Then other consideration that you need to have will be like your industry standards. What do your market competitors do with the IP? Do they typically file the patents or they keep it as copyright and confidential information? If let's say they typically don't file a patent, then you will also not want to file a patent because you do not want to share your invention with your market competitors. Because for patent wise, the information will be in the public, will be published 1.5 years after you have filed the first application. So you have to look at your industry standard, what typically your market competitors are doing with their IP. Then fourthly, you have to look at the market competition. If let's say you are in a very competitive market and you want to ring-fence your technology because you have put in a lot of effort in your R&D, so you want to make sure that you can reap the maximum benefits from your research. So then you will be more aggressive in filing your patents to prevent your competitor, to set the entry barrier, prevent your competitors from entering the market. Then the next will be your business goal. So you have to look at what you hope to achieve for your business. Do you want to keep it as a family-owned business, or you want to make it into a multinational company, go into a multinational company, or you want to have ultimately have exit strategy like an IPO or M&A. So then different business goals also determine what type of IP you want to protect. Because if let's say you're just a family-owned business, then you may not be so interested in your expansion plan. So then you want to minimize the cost you want to spend on IP. If you want to make use of the valuation of IP, then you want to consider different types of IP to increase the valuation of your company. And for the patent, if let's say you decide to file a patent, when do I file a patent? So first of all, we should understand that for a patent, there are different objectives of why we should file a patent. First of all, the first utmost objective, which is to protect the invention, because that is a technical disclosure on protect the invention. Secondly, is we look at it as a legal instrument because a patent will ring-fence your territory. So you want to exclude others from commercial exploitation. So if people will not infringe on a patent, if anyone infringe your patent, then you can sue your competitor for infringing the patent. So you want to have the freedom to operate. So that's why you want to file a patent to exclude others from the commercial exploitation. Then lastly, you want to use it as a business tool because once you have patent, you have the business opportunity. So you want to make full use of like getting the make full use of the market opportunities, and then get your return on investment from the patent. So that's a three reasons why we file a patents. So for the patent timeline, there's a very long process. So what typically happens is like we will file a provisional application, especially like for the startup because we are budget constrained. So typically we'll file a provisional application to just have a priority filing. So there are different ways of filing the provisional application. We can file as it is application, which is whatever you have written in the invention disclosure. We'll just file it as undrafted. We don't draft any claims at all. So that in some countries like US, Australia, and Singapore, you can file an undrafted patent application just to secure the priority date. Then if let's say you have a bit of budget, then you consider filing a drafted patent where you get a patent lawyer to draft the claim. So that in Singapore is about 5K Sing dollar. Then after that, in 1 year's time, when after you have done a bit more research, you have more results, then you can file a PCT application. It's called an international application, but it doesn't mean that you have an international. It's not. It's an international application, which meaning that in 1.5 years later, you can actually file in other countries the national filing. But it's not that doesn't mean that you have international protection because it's the patent is not correct yet. So for the PCT applications is about 15K Sing dollar, where you have about I think about 50 different countries that have actually signed the PCT treaty will be actually get the protection from those will be able to file later on in the regional office and the national office. So 1.5 year after the PCT is filed, then the application will be published in the public domain. At the same time, the PCT office, whichever office you have submitted your PCT application to, will be able to have a preliminary examination on how patentable your claims are. Then at that point of time, you can decide whether you want to file a national application later on. Because if let's say the examiner found that your claims are not novel and inventive, you may consider not to invest further in that patent application, unless your patent lawyer is able to amend the claims to overcome the prior art. So if let's say your patent application is found to be novel and inventive and have industrial application, so meaning that it's likely to be patentable, then you will decide to progress into the national phase. Then national phase, at that time, you have to decide which country you want to file in, because that's when you have the protection in the different jurisdiction. So the PCT application is just opens the door for you to file in the national application later, but then you will not have any protection. The protection only comes in when you file in the national with the National Patent Office, and then the patent applications are being granted. And that whole process will take about depending on how fast the examiner comes up with the grant patent. So it's usually typically is about 5 to 6 years from the first filing. And then when you file the national application, although depending on which country you're filing, some countries like China, Korea, and Japan, you need to have translation. So you have to take into consideration the translation cost. And typically for a patent application, you will expect like 2 to 3 office sessions before it's being granted. So typically, like for example, if you just file in US and Singapore with no translation cost involved, for the application, it's likely to cost about 50K. So if let's say you want to file in many countries, then you have to budget for the patent applications. So what is your consideration? You have to consider your cash flow. So what you need money for your R&D and also hire staff. If that is you require the money for all the resources, then you also have to budget for the patent application to determine whether you want to file in many countries for your first application, for your first patent or not. Then you have to solve because if let's say, for example, you are going to have any public disclosure, like for example, you're going to present it to an investor, of a pitch competition. Then if let's say you're going to have a public disclosure, it's best to file a patent application before you go for any public disclosure. Because if let's say you have any public disclosure, then your patent will not, whatever your public disclosure will become your priority if you file a patent application later on. So typically we encourage the inventors to file their patent applications before any public disclosure. For some countries like US, Singapore, there is like a 1 year grace period if let's say you have public disclosure, that you have a publication or any oral presentation. There's a 1 year grace period for you to file your patent application. But the best thing is to file a patent application before any public disclosure, so that your public disclosure will not end up becoming. Then also you have to also look at your same thing. You have to look at your market competition, whether how aggressive your market competitors are in filing the patent application, because you don't want to. You want to have a freedom of it, so you want to. If let's say your market is very competitive, then you want to file a patent early to secure your market opportunity. Then at the same time, you also have to look at your technology development then, because depending on how fast your tech research plan is, because sometimes if let's say you may have one invention and you see that there are a lot of refinements required for invention. So for that, you may not want to file your patent application too early. You want to wait until that you have all the final modification before you file your patent application. Because if let's say you're going to modify your invention, then whatever you have filed earlier may not be relevant, may not be sufficient to protect your invention. So you may want to wait a bit to also save a bit of cost before you file your patent application. So there are different considerations you need to consider before you file a patent application. Then after that, once you have decided that you want to file a patent application, then you want to decide where do I want to file my patent. Because you know that for patent application, there's jurisdiction specific. So that will also, you have to consider, like for example, I have two examples over here. Like for example, you have a biotech company, you have a gene editing technology for agricultural application. So in this case, the conservation, because you know, like for biotech patents, requires a lot of like testing and regulatory approval. So therefore, you want to, because of all this investment you have made in the technology, you want to make sure that your patent will definitely get granted and the patent laws are favorable for you. So you make sure that if there's someone infringing your patent, you must be able to go to the court to sue your infringer in that particular country. So you want to target countries that have favorable patent laws. And also because if let's say you're looking into agricultural applications, you want to protect your patents in the countries where these have a huge market share for agricultural products. Then for the next example, which is a multinational corporation, we're looking into like wearable electronics. So we know that like for wearable electronics, consumer electronics patents, they actually like very fast moving. So if they say the technology is very fast moving, then we will not want to file too many patents because the technology changes very fast and there's a global competition. So which means that when you want to file the patents, then you have to be more strategic on which one you file. If let's say it's going to be very fast moving, it's going to have improvement within weeks and months, then it may not be so advisable for you to file patents. So you will select the patents which one to file. So you will not file patents for every invention. So the consideration, you have to look at the market potential, whether the patents that you're filing in, are you filing in the countries where you have the huge market interest, because you want to ensure that you get your return on investment. So you want to file the patents in countries with huge market potential. Then the next thing is to look at patent law. whether this, if you have filed a patent in this country, whether you are able to enforce a patent. If let's say you're not able to enforce the patents in that country, then you may not want to file the patent in the country. And also different countries have different patent laws. Some countries may not allow some subject matter reform. Just like, for example, method of treatment. In Europe, you cannot file method of treatment, but then you can file method of treatment US and Australia. Then also you have to look at your strategic objectives as well. Key competitors, where they file the patent in. So one what I've done with some startup in Singapore, I help them in looking at the innovation patterns. Like for example, they will list the market competitors. Then I will look into do a pattern search on what the market competitors, the patterns that market competitors have filed. Then I map out the pattern landscape. So where they focus the innovation in. And then I identify the white spaces to my clients on where they can focus their research on and where they can file the patents in. Then other strategic objective, we look into your market expansion, where you want to expand your market into. And also, if let's say you can't manufacture in your own country, you want to manufacture in other countries, then you also have to file the patent in the country where the manufacturers are in, so that they have the right to operate and the ability to manufacture the product for you. So what can I say about patents? There are 3 P's that can conclude, which is if let's say you need to file a patent, it's a very expensive process, and you have to plan your IP strategy wisely, looking into the market landscape and the patent landscape to decide whether which type of IP is suitable for you. You have to plan your IP strategy wisely. And then, because for all startups, we have the budget constraint, which means we have to prioritize our resources, because we don't want to be too aggressive in our patent filing and to not have enough money for our research and hiring talents. So that's why we need to prioritize our resources, pace our budget, such that we have sufficient budget to do the things that we want to do. So these are the 3 P's and advice I have for you on the IP strategy. I'm happy to take any questions.
Thank you very much. That was amazing. And while you were presenting, Shirley, I couldn't help but wonder myself at a few questions that came to mind, especially considering that the process can be quite expensive, and there's also all these considerations. At what point do you recommend that startups begin to get intentional about starting that process? At what point in terms of their journey, in terms of their revenue, at what point generally should they start?
I think for startup, actually, they should start from right at the beginning. So they be keeping track of the inventions. So because they have to make sure that their inventions are being protected, and actively looking into the patent landscape in the IP landscape, into what their competitors are doing. So to make sure that you are in a good position before you enter the market, because you don't want to be entering the market to be hit by any of the major competitors in the market. So you want to have a smooth entry into the market. So it's important that you have to consider IP at a very early stage, but to be very strategic in how much you want to spend in your IP, whether you want to file a patent or you want just protecting it as a copyright and confidential information.
Amazing. I welcome questions from everybody. Just raise your hand or drop questions in the chat, and I can read them out for everyone. The second part of that question, Shirley, is because of how collaborative startups are in this day and age, is the fact that you want to be protective of what you're building, but you also want to openly collaborate with other startups. So how do you recommend the startups think about that, open collaboration, yet protecting the intellectual property?
So typically, let's say, for example, I have for the university that say we want to collaborate or we want to, let's say, license technology.
Be on mute, please. Thank you.
Say, for example, we license technology companies or have any discussion with any companies. What typically we'll do, we'll sign a non-disclosure agreement. This is to protect what you have been discussed with the person. If the person were to use your information, then you have the grounds to sue the person for using your information. So what you are sharing with the other party, you should outline that in your non-disclosure agreement. So
Okay.
let's say you're going to have any collaboration, whether it's with a startup or with any big companies, always have a non-disclosure agreement in place where you list down what you have disclosed to the other party and keep record on what you
Okay.
there's a leakage of the information or the misuse of information, you have the evidence to sue the person.
Super, super. Let's take it to the exciting part that startups like to talk about, fundraising. How do you see this space, you as a founder being able to demonstrate that you're on top of your intellectual property game? How do you see that affecting the ease or the possibility that founders are able to raise funding and really demonstrate competence to investors? What's the relationship that you're saying?
So you mean like to have confidence of the intellectual property and how actually present themselves to investors? Is that your question?
No, the question is, what is the correlation between I have my intellectual property house in order and I'm able to raise funding? Is there a relationship?
Because usually for investors, they'll look at the strength of your intellectual property, what kind of intellectual property you have, and how is your intellectual property compared with your competitors. So whether your intellectual property, the invention the technology that you have is addressing an unmet need, or is it in the technology you're addressing a very crowded space? If let's say your technology is addressing a very crowded space, then investor will tend to actually have a look or place a lower value on your technology. But if let's say your technology is addressing an unmet need, then most likely you have a higher value on the technology. At the same time, for technology-wise, if let's say you're a patent, then investors will look at the strength of your patent, whether your patents are novel and inventive, how many patentable claims you have. Based on patentable claims, you also look at the freedom to operate. So even though that you may have a granted patent, but you also look at in the countries where you file the patent in, and you will look at the freedom to operate of your patent with other patents to see whether you have the freedom to operate in the country or not. So if let's say even you have a granted patent, but you don't have limited freedom to operate, this will also lower the value of the valuation of a company. And investor will be more reluctant to invest in it. So that's the correlationship between fundraising and IP. So it's important for companies, especially deep tech companies, to have a strong IP to invite more investment.
Super, super. A second part of that question is for founders across board. A lot of the founders here are very early. So in your experience, what are the mistakes that you see founders making that you could, advise that we be aware of and not make?
So I think just from my experience working with the startup in Singapore, because I work with the university startup. So for the university startup, most of the startup founders are students. They're graduate or undergraduate students. So most of them, they do not have any experience starting a company and running a company. So typically, because most of them are more like deep tech startup. So founders tend to be more focused on the technology. And because most founders are like engineers, so the engineers have the mentality of I'm just generalizing, I'm not offensive if there are any engineers in the audience, but they used to have to want to perfect the technology but then they forget that actually the market is moving very fast. So they can't keep focusing on technology, but they have to go to the market to actually reach out to investors to sell the technology, reach out to customers to sell the technology. So they have to balance the perfection of the technology with the market strategy in order for the company to survive. And that also helps them in rationing their resources, because they can't be putting all the resources just in R&D, but they need to actually reach out to the consumers, investors, get the finance to fund the R&D. So there must be a balance between the market strategy, business strategy, and the R&D.
Amazing. There's a question in the chats from Mahira. It's how can my startup on mental health ensure its unique mental health methodology or app feature is protected from replication by larger competitors?
So I think for app wise, it's more like the app architecture and the algorithm and the source code. That will be the IP that an app will have. But in terms of, let's say, for example, if you are looking into the markets strategy, then you want to compare the different features that the different competitors may have in their app features. But then in terms of architecture wise, I'm not a software engineer, but I would say that there'll be different approaches for you to design the app to have that feature. So it really have to boil down to source code, which is sometimes a bit hard to tell, like whether this person has the same source code or not. And also, like if there's some people have used it from the open source, then if let's say you have used the source code from open source, then you already have to look at the licensable rights that is available in open source, because whether you still have the rights if you have obtained any source code from the open source.
Super. There's a second question in the chat from Hamidul Islam Prince, and it's, I create a pattern for my company. How would I know that it's registered by another person or company or anyone else using the same pattern?
So I think, let's say, for example, if it's a registered design, then you should be able to find from the patent office whether someone has registered the same design.
Melu, I hope that answers your question. If you have a follow-up on that, please drop it in the chats. I think it goes without saying that apart from the official records, which is a very good source of validating if you have a copy or not, that would be every other thing that you can do is basically guess, and that wouldn't be a clear validated way to confirm that there's a spin-off.
And on top, sometimes maybe the attendance conference or the way do it or market survey, sometimes you happen to see similar patterns, then you may have there's some infringement. So you just have to be more active in your market survey because sometimes you may see people may not have registered it, but then people have been using it. Then if there's any similarities, then you will see that whether whether the person has copied from your design. And also if there's someone you say that this person has copied from your design, then you also have to look at the date when this design is being produced. So who has earlier date to determine who is the originator of the design.
Shirley, there's a follow-up question from Hamidu asking specifically what's the name of the platform to go to verify this.
So basically, it's there'll be a different patent office where you can search for the design. So let's say, for example, you are operating in this, let's say in India market, then you want to go to the patent office to see if anyone has registered in design in the Indian market, because you don't want to have any similar design which actually have wrong impression of that this person is actually the same company as your company.
Okay. Hamidu, I dropped a link in the chat so you could search out the patent office in your country. You could find, if there's if there's a name it's called, or a unique name that it's known by, then you could search it out and go there and see what the records are and see who has what you may already have. Okay, we're almost out of time, so if you have questions, now's the time to drop it, because we're counting down now, 9 more minutes to go. So throw the questions in. We're more than happy to take them.
All right, Henry, I guess that there are not too many people who are concerned about patent in this group. I can see only 2 or 3 founders, those who have patents, they are here, and most of other startups are mainly kind of, okay, they're working on technology things, so they don't find anything around their business to be patented or any IP there. So most of the cases in our University Innovation Hub program, where the students are working on something, on scientific things, they find a lot of intellectual property things they have to work on. So I guess not too many people. So I'm asking again them. So if you have any question, কারো যদি কোনো question থাকে, question করতে পারেন regarding your startup. So intellectual property might be quite a niche thing for startups, I guess. সবার হয়তো বা not everybody needs this knowledge, but still, if any of you have question, you can ask questions. Otherwise, I guess we have 8 more minutes to go. Okay, or if not, we can quit earlier. Yeah.
Absolutely. I guess a few final words before we go. At the end of the day, in this journey, knowledge, what you know and how that translates into your solution and the advantage it can give you is really what makes the difference. And your ability to protect that advantage for an extended period of time using official tools or pathways is the essence of this session, and I believe that it's probably one of the most important aspects of your journey in innovation, whether software, hardware, deep tech, biotech, whatever it is that you choose to innovate, whatever the industry or sector you choose to innovate in. This is essentially what's gonna eventually make the difference in the long term. So it's absolutely critical. And for everyone that has joined the call, sure, a few things you've picked up newly. I encourage you to take your time, research further, expand your knowledge on it, because you would need it. And it's best that you already know enough to be able to then search for more when you actually begin to face the realities of needing it. But otherwise, I think it's been a great session. I've learned a lot myself. And Shirley, thank you very much. But I'll let you leave us with some final words if you have any for us.
Yeah, thank you for the opportunity for me to share about intellectual properties. I think for different startups, they have different challenges of whether intellectual property is critical for them at the start of the founding stage, or is it like something they should consider later part of the founding stage. So it really depends on like the situation they are in, or how they want to plan their resources. I think for, let's say, for in some country, also looking in the government policies, like for example, if let's say in your country there's a lot like some funding or like subsidies that your government can provide in the startup, that would be good for you to help you in funding your startup. Because if let's say we try to typically, what I typically recommend the startups in Singapore is to use the subsidies and all the grants from the government first before you make use of the investor money. Because usually when you want to raise fund, get the investor money, then usually there will be some requirements and from the investors, and most likely you have to give up some shares to the investor in return for the money they have invested into your company. So it's for you to decide that what comes first is always to pick the free money first before you think of money with obligations. Then after that, you look at what are the things that you in your market and business strategy on what you need to do to have a successful market entry. So I think this is important to actually have a solid business plan before you consider your market entry, and in your planning your market when you're writing your business plan, it's important to make sure that you have make all the consideration, your cash flow, your talent retention, because in the startup, the challenging for the startup is usually the talent retention. Like for me, like I also have a brief stint working in a startup before. And though it's not really a deep tech startup, it's more like a supplier startup, allergy immunotherapy supplier startup. But then it's more like we need to actually get a lot of sales to retain the staff. So that was the challenging part for all the startups, is to retain staff and how to actually have the staff motivated to help you advance your company. So that as a founder, I think that everything, the finances, talent retention, and market strategy have to be balanced to ensure that your startup will be successful. And I wish everyone all the best in your startup, and look forward to see the success in your startup.
Thank you.
Thank you.
Thank you, everybody. And enjoy the rest of your day, evenings, everyone. Cheers.
Thank you.
Thank you.
Take care.